Yes, hi everyone. In this video, we're talking about property disputes and trusts in UK. And the information is not advice and should not be treated as such. Now, I'm giving this example. The sole legal owner has paid the purchase price of the house, and a non-legal owner claims an interest in that house. How can he claim it in the absence of an express trust declaration? Starting point. There's the presumption that the sole legal owner has the sole beneficial ownership because he has the sole legal ownership, and equity follows the law. What about a resulting trust in favor of the non-legal owner? There is no room for a resulting trust because there is no direct financial contribution towards the acquisition of the house. So what can the non-legal owner do to claim an interest in that house? The non-legal owner, however, can rebut the presumption by establishing a common intention constructive trust. That's an common understanding that he would have had an interest in that house, meaning a common intention between them that the non-legal owner was to acquire a share in the house, and also detrimental reliance by acting with that common intention by the non-legal owner must be shown. He can acquire an interest through a common intention constructive trust in the following ways. That is, either through an express agreement and detrimental reliance on that agreement, or through direct contribution to the purchase price of the house. That's mortgage payments or lump sum, and detrimental reliance, of course. The payment itself could be regarded as detrimental reliance, though this inference may be rebutted if positive evidence that no agreement was made is shown. This is not applicable in our case since he hasn't made any financial contribution towards the purchase price of the house. Or through an indirect payment, household bills, etc., an express agreement and detrimental reliance, or an inferred common intention in that house based on the parties' evidence. Regardless of which way common intention arises, there must be also detrimental reliance for the constructive trust to arise. If there is no detrimental reliance, a constructive trust will not arise only if a common intention is found, because equity doesn't assist a volunteer. Now, rebutting the sole beneficial ownership presumption. Now, if a constructive trust is proved, the presumption will have been rebutted, and the non-legal owner will have acquired an interest in the property. The legal owner will still hold legal title, but they will be tenants in common and in equity, and remains to determine what the non-legal owner's extent in the house will be. This process is known as quantification. The extent of that interest. Next, the court will quantify the extent of the share based on the evidence that has been proved. There are various ways to do that. Quantifying the share based on express agreement, or it could be based on the value of the detrimental reliance suffered, or even on the value of financial contributions to the purchase price made, or through a wide range of dealings, including indirect financial contribution, so long as they relate to the property, or infer a common intention, or even impute a common intention through their conduct. How can the sole legal owner defend the claim? The sole legal owner, however, can prevent the non-legal owner from rebutting the presumption if he prevents him from proving a constructive trust in the house and therefore acquiring a beneficial interest in the house in the first place. What must the non-legal owner do? He has to defend the presumption. He can do that by denying that a trust existed and by impeaching the evidence of the non-legal owner, who will try and prove a certain extent of the share, which if quantified would reduce his own equity. Thank you for watching. Please subscribe to my channel for more videos like this. I'll see you on my next video.